I call on Government Orders of the Day numbers 1 to 3.
Legal Services Bill, Committee Stage continue. Financial Markets, Regulators and Kiwi Savers Bill, Committee Stage. Securities, Trustees and Statutory Supervisors Bill, Committee Stage.
I declare the House in committee for further consideration of the Legal Services Bill and consideration of the final Financial Markets, Regulators and KiwiSaver Bill and the Securities, Trustees and Statutory Supervisors Bill.
Mr. Speaker.
Mr. Chairman.
Members, the House and Committee for further consideration on the Legal Services Bill and consideration on the Financial Markets, Regulators and KiwiSaver Bill and the Securities, Trustees and Statutory Supervisors Bill. Members, when we last considered the Legal Services Bill, debate on Part 3 was in progress. Sua Williams CO has the call and has 2 minutes and 34 seconds remaining if he wishes. No? All right.
Vote.
Charles Cheval.
Thank you, Mr. Chairman. Mr. Chairman, perhaps just starting with subpart 1 of Part 3, which transfers the administration of publicly funded legal services from the Legal Services Agency to the Ministry of Justice, and goes on to provide that the Secretary will be responsible for establishing and delivering legal services. Sarah, I note that Clause 68 sets out the functions of the Secretary, including assessing and determining the need for legal services by people with insufficient means. Now, clearly, it's of concern to members on this side that there are reports that so many people are having difficulty accessing legal aid or legal services that they're actually having to consider representing themselves. And I'm concerned that there's an idea that there are more legal aid payments being made, which seems directly related to the increase in both summary and indictable charges rather than the, I think, misconstrued idea that lawyers have somehow been gaming the system. And it would be good, I think, I welcome the presence of the Minister and the Chair. I think the last time we, or at least I was able to participate in the committee stages on the bill, we had another member of the Executive sitting in his place. I do think some of these issues do need to be the subject of reassurances. So the Secretary for Justice will have the flexibility to establish different legal services and different methods for delivering those services. The Secretary will be able to determine which method of delivery is most suitable in a given situation, whether by salaried lawyers as part of a public defender service, private lawyers funded by legal aid or services provided by community law centres. And obviously that flexibility, if it operates well, is to be welcomed. But there are some concerns around the clause, and I'd like the Minister to consider taking a call to let us know his views on whether or not, in fact, we're giving too much power to the Executive, and in particular the Secretary for Justice. The Minister will know that this is a concern that was raised by the Law Society in this process. I think also it would be useful to hear from the Minister how the actual need that is out there for legal services and for representation will be determined by the Secretary, and whether the issue of how community law centres are to be resourced on an ongoing basis is going to be front and centre in the mind of the Secretary when the Secretary for Justice takes on this function. I'd also be very interested in knowing and hearing the Minister's view on why there doesn't appear to be any obligation to consult with anyone or any group when determining the allocation of legal services. Surely a statutory obligation as to consultation, which is something that appears to exist under the current scheme at the moment, would actually encourage better outcomes. Now, I note that the departmental report, which was considered by the Select Committee, says administrative practice a good administrative practice indicates that consultation will occur. Well, if that's the case, Sir, then it would be useful, I think, to hear the Minister on why we don't just codify the requirements so we're assured that it'll occur rather than just fall by the wayside. Sir, I think the other matter that's worth drawing to the committee's attention is the insertion by the Select Committee of a new clause that the Secretary must undertake or fund law-related research and education, which was something that was asked for by submitters to the Select Committee. If that is going to occur, then how does it gel with the funding gap that the Minister has pointed to real concerns about? I think the figure that we heard was $400 million in years to come, and the Minister's nodding his head, so obviously this is a matter that's been thought about. What obviously we want to hear about from the Minister is how we're going to reconcile what he says is a major funding gap coming up in the out years in particular with this obligation that the Secretary is to undertake or fund law-related research and education. So, Sir, on those points it would be helpful, I think, to hear the Minister's views. Going on to the rest of the part, Clause 69 empowers the Secretary to contract with lawyers and law firms to undertake legal aid work. Presumably that provision is, Mr Chairman, presumably that provision exists to allow for providers in remote areas where there isn't a good service in a particular area of speciality to actually assist with those who can't afford to pay for their own lawyer. And Clause 70 goes on to establish the Office of Legal Services Commissioner. On Clause 69 and the interplay with the clauses that follow, I'd be interested in knowing whether the Minister's considered restricting the percentage of legal aid work that a lawyer or a law firm can do instead of leaving the position open so that all of the work that perhaps a contracted law firm might end up doing is legal aid, and whether he thinks that would actually be a desirable situation in any particular case. And obviously from the Minister's facial expression, he's considered that matter seriously too, so it will be helpful, I think, for the House to hear from him on that issue. On the issue of the Legal Services Commissioner, what we have, as was said in previous contributions in the debate, is a move from an independent entity into the core executive. The Legal Services Commissioner within the Ministry will be responsible for the granting of legal aid, the determination of legal aid payments, assigning and managing legal aid lawyers. These were all formerly functions of a Crown agency, the Legal Services Agency, which will be disestablished by Clause 117. Part of the work of the Commissioner will be independent, but also much of it will be carried out by the Ministry or the staff of the Ministry under this legislation, and that won't be done independently. So I think we do need to hear from the Minister about what guarantees are in place around the independence of the role of the Commissioner, and in particular the staff who are employed by the Secretary of Justice but under the effective management or direction of the Commissioner. So, Sir, I have also got some concerns around subpart 2 of part 3, but I propose to leave those matters to later in the debate if I have the opportunity to take another call, because I do think it would be good to hear from the Minister on the other matters that I've raised.
The Honourable David Parker.
Yes, thank you. Following on from my colleague Charles Chevelle's comments, I want to just address the issue of community law centres just a little further. The Clause 94 of the bill, which sits in Part 3, says that the Secretary may enter into contracts with community law centres. And I presume that it's through those contracts that the Crown sets out the sort of work that they're willing to fund community law centres for. I see the Minister nodding. That's a good thing. I think I've said previously in another part of this debate that we do need to take care that the primary thing that we're funding through community law centres is actually legal advice. Legal advice for people who need legal advice in respect of problems that they often couldn't actually get a lawyer to be interested in and might not be able to afford to get any legal advice. And community law centres, I think, do provide a very, very valuable and low-cost service to our country when it comes for advice on those generally more minor issues which can be nonetheless important to the individuals involved. Where issues are more significant that come through a law centre's door, and they do periodically, then the normal practice is for the law centre to say, hey, you need some really decent legal advice here from a full-time lawyer rather than a community law centre, and so it gets referred on to a lawyer. Right. Where there can be a problem is where you can cross the line between what is appropriate advocacy by community law centres on matters of principle to advocacy in favour of political causes, and I have on occasion seen that from law centres where I think there have been perhaps applying the money that they get from the Crown to political causes which they no doubt believe very strongly in, but given that there's an opportunity cost in them applying their resources to those tasks, the opportunity cost is that they're actually not spending it on legal advice for the people who come into legal centres in respect of legal problems, and I think that that balance needs to be carefully preserved. One of my reasons for that is because I believe strongly in the importance of law centres. I'm concerned that if we don't protect their core function, then if you get a law centre that goes too far with political advocacy, you can annoy a future government, and I'm not saying that there's a current intention on either law centres or current government, but you can actually see that you could set up a set of events which would lead to funding for law centres being reduced in a way that would be to the detriment of the people who need advice from law centres, and that advice is far cheaper than any other means that we've got of delivering legal advice to people in New Zealand. It's cheaper than any other form of legal service, either privately funded or through legal aid. Mr. Chairman, the other issue I would like to touch upon briefly relates to civil legal aid, because although some of the rules that are being changed here in respect of the Legal Services Bill, they change the way in which legal aid is granted. They actually don't change the efficiency of court processes. And the problem that we have in New Zealand is that court processes in the civil arena have over the years become too complex. They've become so complex that a lot of people can't afford to access justice anymore. Whether they're eligible for legal aid or not, often legal aid is a loan to them. It has to be repaid. It's a cost to the Crown. It's effectively a loan to the individual who gets legal aid that has to be repaid in the future. And whilst legal aid is very important, and I don't decry the importance of legal aid, the more important thing, in my opinion, is that we reform our civil court processes. Our civil court processes, and I was a civil litigator for many years, and I saw the change in process during the couple of decades off and on that I was practising. I saw civil processes become more and more complex. I have no doubt that if you run the full gamut of a court process through all of the interlocutories that can be forced upon parties these days, whether it's applications for further and better particulars of the statement of claim, whether it's questions asked before trial which are called interrogatories, whether it's the proliferation of expert evidence that seems to be admitted to courts, all of these things are driving the length and cost of proceedings. Now, when we get an outcome from a court decision, the outcome of it these days is near perfect. Not many of them are turned over on appeal, but there is always a trade-off between perfection and cost. And when the pursuit of perfection goes so far that we get the cost of legal proceedings because the processes have become so tortured and long, when the cost of those long processes becomes such a sum, Mr. Chairman, when the cost of those processes becomes so